So sit back, relax, and join the ride, as they say. So let me share my screen here, and we will get that going. So everyone should be able to see the screen here too.
Yep.
So with that in mind, the first couple of slides just has some of the biographical information for us. I laughed because I'm wearing a suit. I probably worn a suit twice in the last year with that picture being one of those days. So there's some stuff about me, stuff about Megan, also nicely attired on that day. So again, it's been a long time since we've been wearing suits around here, but I don't even know mine would fit right now. We'll find out someday. So getting to the substance of the matter here, the first question is, especially for our children or other family members who are on the webinar today, is what the heck are my parents doing in the first place with working with us, and what are we doing with them, and vice versa? And how might I, being the successor person, child, beneficiary, trustee, etc., how am I involved in all of this? So the good news, perhaps it's good news, is that you are involved. Now, some people may come out later when they're administering an estate and say, boy, this is more than I wanted to get involved with, but hopefully not. Hopefully through the process that we follow here, and the fact that your family member, our client, is involved in the maintenance program will make the administration of the estate, either during an event of incapacity or upon death, a lot less stressful and difficult than it might otherwise be. And so we start with the premise that most estate plans don't work. What do we mean by that? Well, for those people who've worked with us, they sort of know the routine when we get into this conversation. What we say when most estate plans don't work, that doesn't mean that whatever legal documents a person has created, whether it's a will or a trust, or even just an in trust for type designation, doesn't do what it's supposed to do. But rather what we mean when we say most estate plans don't work is that the results that the person who engaged in whatever planning was done intended to happen doesn't really take place when all is said and done. A best example of that is people have your basic wills that say that would say I leave all my estate 50% to my son John and 50% to my daughter Susie. Come fast forward 25 years after they sign the will, at the time of their death, Susie ends up with 80% and John ends up with 20%. How did that happen? The will says 50-50 between the two kids. Well, invariably what we see happening is that as the parent, let's say his name is Frank, got older, and Susie lived down the street from Frank, he put her on the bank accounts to help pay his bills and just manage his financial affairs. By adding someone to a bank account, that has the legal effect of making them a joint owner of that account. So in my example, when Frank passes away, all those bank accounts that have Susie on them go to Susie. John doesn't get anything, but he protests. It says 50% under the will. Well, the will only controls assets that were solely in Frank's name at the time of his death, which of course did not include those joint bank accounts. So here we have a whole kerfuffle between the two kids. Susie says, no, that's what Dad wanted, so I get those assets. And John says, no, it says 50-50, so he sues her, and all heck breaks loose, as they say. So that plan did not work, because if you had asked Frank before his death, how do you want your assets to pass? He invariably would say, I want it to go equally between my kids. He didn't realize, as most people don't, that when he added his daughter to the account to help pay his bills, he actually gave her legal ownership of those accounts at the time of his death. And this is the kind of thing we see repeatedly over and over again that happens, and that blows up the plan. So in our process, as we'll get into a little more, that kind of thing should not be happening. So Megan will tell us about how we define estate planning in our practice and how we put it in play.
Right. And so, as Rich just discussed, something like a will is just really one part of a bigger picture, right? It's a means to an end, it's a tool. But really, for an estate plan to be successful, we have to look at these different elements of it. So, here we have the definition of estate planning from our perspective, because this is what we feel like most people want when they come to us to say, I need a will or I need an estate plan. So there are a few elements here and we'll go over them. The first is that the person wants to be able to control their property while they're alive and well. Makes perfect sense. It's everything that they have been working for and earning over the course of their lifetime. So they want to stay in control of that. And while they're alive and well, they're going to be the point person for their property. And while they're alive and well, that is the perfect time to put their plan in place to say what happens when they are maybe alive but not so well, and what happens after they pass away. So always maintaining that element of control is a really important factor, and it can be done through a well-crafted estate plan. The person is typically also wanting to plan for disability. So estate planning is not just death planning. It's planning for the event of maybe a person getting older and needing additional care at home, or potentially losing capacity and no longer being able to make financial decisions for themselves or healthcare decisions for themselves. So these are just two of the elements that a good estate plan should have at the forefront and be planning for or keeping in mind when these documents are put together. So here we have a depiction of what our standard revocable living trust might look like. So I don't know who most of you are joining here for, your loved one, parent maybe, but it's very likely that their plan contains some kind of trust, and a revocable living trust is a really good foundational document to start with. And again, we're talking about maintaining control while the person is alive and well, and then having some kind of element in their plan for disability. So something like a revocable living trust keeps that total control with the person who's planning. So with the trust maker, your parent. It's using their social security number, whether it's an individual trust or even a joint trust, still using their social security number for the document's tax ID number. The trust is technically an entity, so we have to have some kind of identifying number for it. But that social security number really allows for pass-through taxation to your parents, so they're not concerned about additional tax filings or anything like that. Your parents or your loved ones, whoever you're joining what for, they're going to be the trustees during their lifetimes, as long as they don't have some reason that they wouldn't want to serve as their own trustee. And that trustee is the person who continues to control the trust property. So even once they transfer their property into their newly established trust, they continue to control those assets, where they're managed, whether or not they make a distribution. All of this is just like those assets are still titled in their own names. We also have the disability elements. So here, while your loved ones are able to, they have capacity, they can think about this, they're going to designate who the people are going to be that are in charge of their trust if they couldn't do it anymore, and how they are determined to no longer have capacity or no longer be the person who really should be controlling the finances. We don't want, and your loved one doesn't want, a situation where they have to go through something like a guardianship proceeding, which is a very invasive court proceeding, in order to be determined or declared incapacitated, and now someone else steps in and it's really up to the court's discretion. By adding the provisions to their estate plan through this trust document, they choose who serves on their disability panel. Instead of the court making the determination, their loved ones, the people that they trusted most, you guys, you're going to serve on the disability panel. And if you come together and say, you know what, mom or dad really shouldn't be managing finances anymore, through some paperwork that would be prepared in conjunction with us and other people on the panel, you guys would be able to say, let's remove mom or dad just to protect them and their assets. And then whoever mom and dad designated as the successor trustee then fills those shoes. So still there's that element of control because your parents mapped all of this out. They made all of these decisions and they chose you guys to serve on their panel or as their successor trustee. So even when they can't actually control their assets, they're still controlling what's happening.
Yeah, so the top part of this in the alive and well phase, doesn't even really feel like a trust. The trust exists, the assets are owned by it, but the parent or the client is in full control of it, just as if it was in their name. So it doesn't have the feel of a trust. But then when this aspect kicks in, when there is the incapacity, and we have to have a transfer of authority from the client to the children down here, that's when it becomes more of a real trust. Someone else, a third party trustee, i.e. you, is now administering the trust for the benefit of someone else, i.e. the parent. So, in an example of this, we see instances of elder financial fraud and abuse that's just running rampant out there. I was just home at lunch and we got a call and we were expecting a different call. So my wife answered the phone from someone, recorded message that her social security number had been discontinued. So she had to give all kinds of personal information. Now, again, that seems silly. Who would do that? A lot of people do it. They just are. The reality is people as they age, not everyone, but a fairly substantial portion of the population loses their BS filter, if you know what I'm saying, right? They just can't differentiate between truth and fiction. We had a woman, very sharp woman, who was contacted by some guy, got a hold of her cell number, started texting with her, promised her that she had won a very lucrative lottery. So it's the classic lottery scam, but she had to prepay all kinds of fees to claim her prize. Well, lo and behold, she was out to the tune of $157,000 before a guardian could be appointed. She did not have a revocable trust. She wasn't our client. Her son contacted us to represent him in the guardianship to have his mother's authority removed. In this context, with this structure, it would have been a lot simpler. He could have kicked in the disability panel. He was an only child, so he and the doctor presumably could have signed an immediate certificate that mom has lost her marbles in a little more elegant language than that. And then she would have not had any further access to those accounts that she was allowing this guy to swindle from her. So that's the bottom line of this piece and why it's so important.
So continuing with the definition of estate planning, this is probably a little closer to what people typically are thinking when they're joining this workshop or thinking about estate planning. It's how do we dispose of the stuff, right? So when someone comes into us, in addition to those other elements, they're also thinking about they want the ability to give away their stuff, whatever things, those particular items that they want to designate, or maybe everything after they've passed away, to those people that they designate. They want to make sure it's getting to the right place. It's not inadvertently going to somebody else that was unanticipated or not really part of the plan. They want to do it at a specified time. Maybe it's during their lifetime, or maybe it's after death. If it's after death, is it immediately upon death? Or are we kicking this down the road a little bit? Maybe you have a minor beneficiary and we're thinking, wait a second, maybe we don't want everything to go to them right away. They're a little too young for this, right? And they want it to get to their beneficiaries or their designated people in specific ways. And this may surprise you. There is more than one way to give stuff or to receive some stuff through an inheritance. The most common way, I think, in other people's plan is going to be something like an outright distribution, and we're going to talk about this more. But what we're typically recommending is subtrusts for beneficiaries. So just as an example, there's more than one way to give your stuff and for someone to receive the inheritance. And then, of course, all of this planning should be done with fully disclosed and controlled settlement costs. So when someone is sitting with us, they want to know what is the cost to do the plan, put it all together and get it going, right? But then also, what does it cost on the back end when I become incapacitated and my family needs to contact you, or after I've passed away? Not only what do they do, what does my children or my loved ones do, but what is it going to cost at that time? And so these are all of the elements of an estate plan. It's not just write some stuff down in a will and after death it magically goes to those people, or maybe not because the plan wasn't so great. It's consisting of each of these different elements.
Right. So underpinning our process is our program called the Legacy Assurance Program. And that really is underpinned by three fundamental pieces. The first one is working with a counseling-oriented attorney, which means people here, Megan, myself, Linda, and anyone else who's involved in our process, to really drill down into what the client's hopes, dreams, needs are, and draw down on our knowledge and experience to get them the best planning result. Beyond that, we want to make sure, and this tonight is part of this, is establish and maintain a formal updating program. We'll get into a little bit about, for example, the changes in the tax laws and how dramatic that has been over the last number of years. And lastly, as Megan just alluded to, we want to make sure that the planning that is done and maintained is administered in a controlled settlement process that is rather expeditious and cost effective for the family. So talking about the first element, the counseling element, there's really two ends of the spectrum. Counseling on one end, word processing on the other. And the example I gave of Frank doing his will 25 years ago, leaving everything equally to his kids, tends to fall under the word processing. Was done most likely by a general practitioner who often is running to family court in the morning, has a real estate closing in the afternoon, might have a traffic ticket to handle at night, and squeezes in a will between all those things. That's how it is. There's no discussion of the assets or funding the assets or whatever. It's quick, painless, fairly inexpensive, but not really much of a value proposition. On the other end of the spectrum is how we operate, is to really drill down, spending hours, not minutes, hours talking and reviewing and updating and constantly tweaking what we're doing. And learning about the family. That's really important. So much planning goes by the wayside because there isn't that in-depth conversation between the attorney and the client about, I understand who you are sitting in front of me, but who are the other people in your world? What are they all about? And a lot of times through that conversation, we will learn information that changes the complete recommendation of the planning as to who's going to be in charge at what time or who's going to get what. It can really be very dramatic in that manner.
And just to sort of add to that, so for each of you joining us on this webinar today, I'm not sure how it's going to make you feel, but chances are we've had a pretty lengthy conversation with your loved one about you in particular. So because you've been chosen, it was only after a discussion and realizing, okay, you seem like the good choice for this position.
That's right. That's a very good point. So you should feel honored that you've been invited to join this program by your parent. That speaks well of you, right? So when we talk about the counseling, here are some of the kind of goals. We want to get the clarity of not only the personal and family story, but of course the financial picture. So many people will assume certain things about their assets that are incorrect. They'll have an account that they are convinced is a joint account. It turns out it's an IRA or it's an annuity or something like that. And so we just don't take anyone's word about what they own. We must see the actual source documents, the statements, the contracts or whatever, because if we don't understand that, we might make serious errors in terms of the way it's planned for. Certainly a fundamental goal, and this has shifted a lot in the last 20 years since I've been doing this, is the concern and the cost of long-term care and the prevalence of it, right? As our population is aging, and we know that's happening demographically, people are rightfully concerned about the cost of long-term care. And we'll get a little into this as we get into the long-term care piece and the disability planning. But right now in Orange County, you're looking at nursing home costs on average about $13,000 per month. So you can do the math. That's a big chunk of change every year if we don't plan for it. Another fundamental counseling piece is protection against the client and their loved one's catastrophic illness, creditors, remarriage, and divorce issues. So, as Megan said, there's common ways to make distributions of assets is the outright distribution. We'll get more into this a little bit about the importance of leaving protective structures against these kind of risks that all of us can face. And of course, there's tax minimization issues. We just did our first of the client update meetings this past Tuesday, and there are some dramatic tax changes potentially on the horizon. There have been some significant changes in the IRA rules, which also have some significant tax implications for the clients, and more likely really for you, the children on this webinar, who may be inheriting IRAs from your parents. So all these are things that we have to stay abreast of and keep our clients ahead of the curve. So this slide really represents, again, part of the counseling spectrum in the process. Anyone who's been to an optometrist or ophthalmologist, which my guess is pretty much everyone who's on this webinar, has sat in that chair like this woman behind the machine. And they have the little things on the side, and the technician or optician or ophthalmologist, whoever is actually doing the exam, will flip the lenses. And what's the famous question? Which one looks better, right? And what is my answer the first time at least? Can you do it again so I can see it again and make that determination? Sometimes it's pretty close. So think about your estate planning conversation like being behind the machine. We give our clients different choices. You can do A, B, C, or D, or maybe a combination of these things. Which one is better to you? So we're going to flip those lenses, and the client, of course, inevitably will say, can you repeat what those are and explain them again, which we will do. But eventually, by giving the spectrum of choices, the client is making the decision. We're not telling them what to do, but we're helping give them the framework of what the options are in each part of the conversation, so that each element is properly and thoroughly addressed. So that takes us to the second stage of the 3 steps of our legacy assurance program, establishing and maintaining the formal updating program.
So we here do have a formal updating program as part of the legacy assurance program. Sometimes we call it the maintenance program. And basically what it's designed to do, it's a process where we get to meet with your loved ones every year. We do these group meetings. Maybe some of you have joined in on those, but we're trying to address all of the different changes that could take place from the date of the original estate plan, so that when it does mature, when your loved one does pass away, we know that that estate plan is still functioning at that time as good, if not better, than it did when we put it together initially. So there are essentially 3 kinds of changes, 3 different types of changes that we want to be keeping track of, and in particular relating to your estate plan. So first is really the changes in your loved one's personal situation, and that can be personal, as in a family situation, their relationships with their loved ones or friends or any other important person to them. Certainly, sometimes people come to us and they have a strained relationship with someone, and then maybe a year or 5 or 10 years later, that relationship has repaired itself. And so the estate plan really needs to be updated to reflect their new wishes or their desires, or maybe a loved one gets into some kind of trouble. Maybe they know they have a child going through a terrible divorce, and they say, you know what, if I pass today, this might not be the best plan for that loved one. Maybe we need to make a change here. So definitely personal changes happening in their lives, and certainly financial changes. And these could be major financial changes, that maybe their wealth has grown dramatically. Hopefully that's what's happening for everyone. Or it can be minor financial changes. So what we see every single year year is many of our clients will move to a different institution or start working with a different financial advisor. They came across a life insurance policy from decades ago that they completely forgot about. How do we incorporate these new financial situations or assets into their existing estate plan? We can't do it unless we are seeing them on a regular basis and checking in with them to make sure that each part of their plan, not just the legal document, but the financial parts as well, are all working together. Another kind of change that we might see, and this is something that Rich mentioned already, is definitely a change in the legal environment. So you're going to see things, and we have seen, Rich has certainly seen, changes in the tax laws. Most recently, we've had major changes in the Medicaid laws, and certainly changes having to do with the personal protections available through the different estate planning mechanisms for your loved ones or even for yourselves. So these are the things that we are keeping track of. We don't expect your loved ones necessarily to be keeping track of these items, but every year when they come in to visit with us, we say, hey, there's a change you need to know about, and it might affect your estate plan. And so this is the solution. These are the new documents that we have available to you, or these are the changes in the provisions. We think it's really going to benefit you and your loved ones. So as the legal environment changes, as legislation changes, typically the legal document also will need to change and be flexible with the new environment.
Right. So following up on the first point, the tax changes, it's a little small on the slide, I recognize, but hopefully you can see it reasonably well. We're going to just take a quick, review of the tax law changes over the years. So not all of these, of course, just the 1913 was the enactment of the 16th Amendment to the Constitution, which for the first time put the federal income tax as a constitutional right or reality, I guess is the best way to describe it. There had been federal income taxes during the Civil War and prior to that, but it was always questionable whether they were actually legal. The 16th Amendment made that crystal clear. Even though there are a few people out there who are still saying that income taxation is not legal, these sort of wacko people out there. Anyway, the Internal Revenue Code wasn't actually enacted for another 26 years in 1939. And then it was significantly revised in 1954. So for the first, 40 or so years, the income tax was a fairly simple thing. The tax rates were pretty low, et cetera, et cetera. And then it really ratcheted up during World War II, especially with the need for revenue. And then 20 years passed, and the ERISA, which still governs most of the retirement plans. Then you see what happens, a rapid increase in the frequency of tax law changes. Sorry, I went a little fast there. I hit the button. Up here, and then in the 80s and 90s, we see a continued acceleration of the various plans. And again, they all have these great acronyms, right? NAFTA, whatever. One of my favorites is 1993, the Clinton's Revenue Acceleration Plan, or CRAP. So, so that's a sort of a fun one. When I started getting into estate planning, it was 1999. So when I was first really introduced to estate planning, this is where I was. Look what's happened since in the 20 years I've been doing estate planning. We had the egg tray law, which changed the significant estate tax exemption increase in 2001. Then we had a bunch of others. And then all of these have occurred during my career. 2003, 4, 5, et cetera. They skipped something in 2007. Well, it was right before an election. That's why, et cetera. We had the Tax Cut and Jobs Act, which was the large corporate tax cut rate that took effect in 2017. And then even onto another page, last year we had the significant Secure Act changes, which modified the IRA distribution rules primarily. And then just past a month or so ago, the American Rescue Plan, or ARPA. And who knows how soon the rest of this slide is going to be completed. So this all leads to the question. If someone did an estate plan in 2003, Do you think all these tax law changes that have occurred in the last 18 years would have some impact on the success of that estate plan if the person who created the trust or will passed away in the interim? The answer is almost certainly it would. So this is why this maintenance program, one of the many reasons it's so valuable. So then we get to the third important change.
Right. And this is the change in your attorney's experience. And this can be one of the issues with someone using maybe a general practitioner for their estate plan. But the idea behind this is that the attorney that's preparing these estate plans, they really should be staying on top of not only the changes in the laws, but also the different tools that are available, different planning tools. I showed you one example of a revocable living trust, but there are dozens of different kinds of trusts and other estate planning tools available, and not every one is right for every situation. And an attorney is not going to maybe know that immediately when they start out, or even after 20 years of practice, because legislation is constantly changing the rules on us. But every year, your attorney should be focusing on their practice and trying to figure out what new tools and new strategies can be used. So here with Richard and I, and there's also Linda's another attorney in our estate planning practice, and we practice exclusively in estate planning, elder law, we're talking about Medicaid, trusts and estates, estate administration. So this is our realm. And because we're practicing in this day in and day out, when we're taking our continuing education courses, we are taking them in estate planning. We are taking them in elder law because we want to be able to serve our clients in the best way possible. And the only way for us to do that is continue to expand the knowledge that we have in our practice area. Now, if I had to, like Rich said before, if I had to cover maybe a landlord tenant matter and then a bankruptcy matter, I would have to try to fill up my brain with some of that information too. And certainly I could try to do that and I would do the best by my client, but that really is not going to be the best estate planning out there, right? There's no way that I can focus my attention on estate planning when I have so many other things going on. So this is just to say that the attorney that you're using should be growing, not changing out who your attorney is, but they should be growing their knowledge and expertise. And if that's not happening, then you're not getting the best estate plan possible. And so neither is your loved one. So these are the things that might change over time. Certainly, Rich, I'm sure, has learned a lot over the last 20 some odd years he's been practicing. And I know I certainly have learned a lot. So we're changing every day. And hopefully those changes are for the better, so that when we're producing documents for your loved ones, those documents are better than when they first came in.
Right. And even though I've only been doing estate planning for 21 years, I've been practicing for actually 22 years. I've been practicing since 1988. And by having had a general practice or some other experience for a decade or so before, it does help give me a foundation of some other information that is useful in the estate planning context. If people say are going to loan money to their kids, I've done promissory notes in the past. I'm doing things of that nature. So there has been some benefit from having some other experience. And hopefully I've been able to impart that to the people on my team, Megan and Linda, and the other staff people as well. So we covered the first 2 points of the 3 prongs of the legacy assurance program. The last one that we'll touch on is the assured controlled settlement costs after your death. In the rest of the estate planning world, if people have that simple will that they did and it's stuck in someone's safe, when the family members, during a period of grieving, almost typically come in to meet with the lawyer, they have no concept as a general proposition of what the cost should be to administer the estate. So the attorneys routinely will say, oh, it's going to be either a flat fee of X dollars or often a percent of the estate, 3%. No one knows the better, and that's what they pay. So if it's $1 million estate, attorney will charge $30,000. And what real value have they provided? In our structure, when our family members, the survivors of the clients, meet with us, we have in our fee agreement with the client a controlled settlement cost so that the family members will know exactly what our fee will be based on the estate. And it's a lot simpler. There's no stress or strain to deal with that. So that's the three prongs of the estate, the legacy assurance program. Now we'll shift gears into sort of some more the practical nuts and bolts of how all this works, both during lifetime and disability and upon death. So we're first going to show you a diagram of a sort of typical joint revocable trust. There's really two varieties of trusts that are commonly used. Again, going back to '99, I was pretty much exclusively doing revocable trusts at the time. Today, we're more commonly doing the Medicaid Asset Protection Trust that we'll discuss in a few minutes. But the main difference between the two is that the Medicaid Asset Protection Trust will help shelter assets from a Medicaid spend down if someone needs long-term care. The joint revocable trust does not do that, nor does the individual revocable trust. And you might ask, well, when would you decide to do a joint trust versus an individual trust, which is a very fair question. Back in the old days, when the estate tax exemptions were much lower, let's say $1 million or $2 million per person, we would routinely do separate revocable trusts because it was easier to administer and handle the estate tax issues that would often arise after the death of the first spouse by having a separate trust. Fast forward to today, the federal estate tax exemption is now $11,700,000 per individual, or over $23 million per couple. And New York State estate tax exemption is almost $6 million per individual, or $12 million per couple. Not such a big issue, so we're commonly using the joint revocable trust structure today. Now, if the estate tax exemptions do decrease, which is one of the things that is on the table to maybe reduce them as low as $3.5 million per person on a federal level, we may go back to recommending for new clients separate trusts. It doesn't mean we can't do the estate tax planning in a joint trust. It's just a little bit more complicated to get there. But whether our clients on the webinar have single, individual, or joint trust, it really doesn't matter. There would be estate tax planning in either case should it apply to your situation. So this particular diagram just shows a joint revocable trust. So what this has, it has that same kind of alive and well piece on the top end, and then we have that disability piece that we talked about before with a reference to our disability panel and a reference to who, the people would be named as disability trustees if the grantor or either one of them, the trust maker, becomes incapacitated. So, but where we are now is what happens after the first spouse's death. Well, what will happen is that the trust will be essentially divided into two parts. There'll be one part that will be the deceased spouse's assets will remain in the main trust as a marital or family trust. There'll be a new subtrust created. And the main revocable trust will also provide that the survivor's share, the surviving spouse's share of the assets will be held in what we call the survivor's trust. That will be really a continuation of the revocable portion of the trust initially. So let's say there's $1 million and it was all jointly owned assets. Husband dies first, and just by way of illustration, the husbands always die first in our illustration. Husband dies first, his $500,000 share will go down into the marital trust typically. The wife will be the trustee of that trust, and that is a technically irrevocable portion of the trust. The other $500,000 will flow into what's called the survivor's trust, which will just be a continuation of the revocable portion of the trust. The surviving spouse, he or she, in my example, can leave those assets to whoever she wants. But the assets that are here, so if the surviving spouse remarries and decides to leave her assets to the new husband, she can do that. But these assets, she will generally not have the authority to leave them to anyone other than the decedent of the husband, right? Typically her children too. Now, a lot of these conversations will take on a little bit different flavor when we get into the context of blended families, when husband and wife do not have the same children, or not all their children are from both of them. A little bit more in-depth conversation has to be had in that case. Another thing about these trusts down here, this one and this one over here, These are not separate legal instruments, just to be clear about it. These are these trusts here spring out of this. So they are technical legal instruments separate and apart from this trust, but they are all part of the same trust. That's why we refer to them as sub-trusts. And financial institutions get this confused all the time. They always say, oh, we want to see the marital trust agreement. And we say there is no separate agreement. It's part and parcel of the same. It's just in Article 9 of the John and Mary Smith Living Trust. So not to get too deep in the weeds of it, we just want to give you the context that this can be a little complex for people to understand as a general proposition, but it's pretty simple in its essence. So after both spouses have passed away, then we get to the next slide. So now we have this carryover from the last slide, the marital and family trust of the first spouse to die, and then the survivor's share. Survivor has now died, and so they have 2 kids. So now everything will pass down to child 1, child 2. Let's assume it's 50-50. Now, as Megan said before, it could just easily say, upon the second spouse's death, everything will pass equally and outright to our kids. But these boxes here represent, in our world of planning, protective trust for the children. And as we'll get to on the next slide, we're going to demonstrate for you why your parents have invariably left you, if you're the child on this webinar, a trust rather than an outright distribution, which if they just sat around the table at the Thanksgiving and said to you, you know, Sonny, we can leave you your inheritance outright or in trust, which way would you prefer? Without any further context, the vast majority of the children would say, give it to me outright. Because the concern, at least in their brain, is when they hear the word trust, that typically to them means I have to ask someone else for the money. And trust can be established in that manner, as we'll get to in a minute. But that's not how it typically is in our case. And by having it in the trust that we're establishing for you, you're going to have enormous amount of legal protections while still having access to the money. So with that in mind, I'll have Megan go through the description of the spectrum of planning.
That's right. And so here we see the different ways that a beneficiary can receive an inheritance. And we tend to think about this as sort of a protection continuum. So what you're going to see on the left side of the screen is the outright distributions. And outright distributions can be made in a few ways, but ultimately just know that eventually, when the funds are distributed outright to the beneficiary, that means it's payable directly to the beneficiary. Then they take that inheritance and they somehow put it in their own name. They put it in their own bank account or they retitle it into their own name. So that's the essence behind the outright distribution. So this can be done in one lump sum after someone passes away. The assets are divided up, and then whoever is intended to be the beneficiary, they receive their percentage, their share, in one shot outright distribution directly to them. It also can be done in phases and stages. And sometimes we do see this in plans that will come in from other attorneys typically. And this is if maybe at the time of the plan, the person, your loved one was thinking, you know what, I want to make sure that they get this inheritance, but if they're only about 25 years of age, they may not be so responsible. So I don't want them to get their hands on everything. So they pick maybe ages. They say at 25, they're going to get a third. Then at 30 years of age, they're going to get the next third. And then at 35, they can get their final third. And hopefully by then they're very responsible and they won't have blown everything that they already received. But even if they did, they have this last 1/3 to rely on. So you can get things like that, or also maybe it's life events. So they say, well, if they're, at that time getting married, they'll receive a portion, then they'll receive another portion for purchase of their first home or birth of their first child. So certain life events that sort of trigger the distribution. So either way, like I said, ultimately, whenever those distributions are made, the funds are payable directly to the beneficiary. And the reason that we don't love that is because that means that once those funds are in the beneficiary's names, they are that inheritance is subject to all of the potential issues, all of the liability that beneficiary and their assets would normally be subject to. So if they had a creditor issue, now the inheritance is subject to that. Or if they're getting divorced, depending on what they did with the funds after they've received them, maybe the inheritance is going to get divided up in the divorce. If they have any health issues, now we have to be concerned about whether or not they might qualify for benefits. So there are a lot of issues with forcing it out to the beneficiary. So instead, when we're doing our planning, we strongly recommend that we are looking more on the right side of the protection continuum here, and that's the in-trust distributions. And as Rich mentioned, the in-trust distributions can be crafted in a way that is most appropriate for the beneficiary's needs or for our client's concerns over their beneficiary. But more often than not, we're looking at the lifetime protective trust for the beneficiaries. And this is a very liberal lifetime trust. It allows for the beneficiary to be their own trustee. Now, the trustee is the person that is controlling the trust and the assets within it. They're making sure those assets are managed correctly, but they're also the one that oversees the distributions and makes the determination on the distributions. So if the beneficiary is their own trustee and the trust is drafted in such a way that says that that beneficiary as trustee can distribute the inheritance out to themselves whenever they want, then that beneficiary never has to ask anybody else for a distribution, and there's no restriction on their ability to access the inheritance. So they can go to their trust, remove from the trust whatever assets they want at the time they need them or want to spend them, and any other assets that they don't need, we recommend they leave in the trust, because this trust, unlike the outright distribution, the trusts allow for protection for the inheritance. So it's not in the beneficiary's own name, it's in a trust they control. And by doing it that way, these assets, the inherited assets, are protected against creditors of the beneficiary, divorcing spouses. If the beneficiary encounters any kind of illness, the trust can work to protect the assets and allow that beneficiary to qualify for government benefits based on the assets in his or her own name. And there is some bloodline protection that can be built into this. So certainly that's going to be up to our client as to whether or not they want to build it in. But the function of that is, let's say you as a beneficiary never get around to doing your own estate planning. Your loved one may have put into your trust, if you don't ever do your own estate plan and you don't ever exercise something called a power of appointment, if they give it to you, then they can be sure, and you can be sure, that whatever's left in your trust at the time you pass away will trickle down to your descendants or go to the next intended beneficiary. So it kind of has an after death provision built into it there too. So the lifetime trust, like I said, is where we find ourselves most often, and this is the most liberal version of the trusts. There are also conservative trusts. This is more structured for a beneficiary who we may have some concerns about. Maybe they're in a relationship that our client thinks that their spouse may try to force them to remove the funds or something like that. Either way, whatever the concern is, in the conservative trust, the beneficiary won't be their own trustee. They'll have someone else serving as their trustee. And then the terms of the trust let that trustee know when distributions should be made. So this could be cultivated really to the beneficiary's circumstances. Your parent or loved one can say, I want my beneficiary to have access to up to 10% of the trust every year, no questions asked. But anything over that, the trustee then has discretion to say, well, what is this for? Do you really need it? Should we be making this distribution, or is it just going to hurt you? So that's a way that the beneficiary would work with the trustee. And then certainly we have the special needs trust, or sometimes known as a supplemental needs trust. This can be structured at the outset of the plan for a beneficiary who we know is qualifying for some kind of government benefit. They're disabled, and since we know that, we want to go ahead and protect these assets for that beneficiary right away. The beneficiary won't serve as their own trustee, but the funds can be used for the beneficiary's needs or wants above what their government benefits should be paying for. Or the other option, and we do this in all of our documents, is to have a supplemental needs trust available as a backup. So if any beneficiaries, maybe you have a liberal lifetime trust or even a conservative trust, if down the road you end up needing to qualify for government benefits, a really neat part of this is that your liberal trust or your conservative trust can be converted into a supplemental needs trust and continue to protect those assets, the inheritance, and still allow you to qualify for the government benefits that you might be seeking, but it'll be based on your own assets. It won't be based on the inheritance, which might put you over a threshold for some kind of resource-based benefit. So by using these trusts, you're not only protecting and preserving the inheritance for yourselves from all of the bad things that could be happening, but you also have the option to then convert the assets into the supplemental needs trust where they can continue to be protected for purposes of any kind of government benefit.
Right. And one other point to elaborate on is we also can have what's called a hybrid trust, which is for those clients who would say, I don't want them to have full control and access because of A, B, and C reason. But I also don't want them to have to ask someone permission to take money out of the trust every time they want something. So the hybrid trust is sort of crafted on a conservative lifetime chassis, but will give the beneficiary the automatic right of withdrawal of either a certain dollar amount or a certain percentage of the trust assets on a given year. So it's sort of literally a hybrid of the two structures. Another popular option that we see out there. So with that piece in mind, we're going to spend a couple minutes talking about the irrevocable trust. We've covered a little bit about the revocable trust. So many, not all of our clients have a revocable trust, and other clients have irrevocable trust, and some have both. Again, it's that very case specific, right? The benefit and the purpose primarily of the irrevocable trust is to start the Medicaid asset protection issue or clock running so that beginning in January, we're going to have a 2.5-year look back for community Medicaid services. That'll be new. Right now, there are no look back penalties for community Medicaid services, which simply means caregivers in a home or assisted living context that are paid for through taxpayer dollars. And of course, nursing home Medicaid has for many years, really going back till 2006 now, we've had a 5-year look back period. So that what that means is that if any transfers are made by a parent to a child or some other family member within 5 years of applying for Medicaid, and that includes both outright gifts and gifts transfers into a trust, those transfers trigger a Medicaid look back, which the assets that are transferred within that 5-year period will result in a penalty period, or really a waiting period before Medicaid will begin paying. Simple example, if $100,000 of total gifts have been made by the parent within the 5 years prior to applying for Medicaid, nursing home Medicaid, there will be in our region a 7.5-month waiting period before Medicaid will pay. Person's in a nursing home, someone's going to pay. The presumption is those gifted assets will have to be repaid. And if they're not paid, the nursing home is probably going to sue somebody or multiple somebodies. So the whole purpose, or the main purpose of this irrevocable trust, is to, while a person is not facing a crisis, and hopefully years before that might become a possibility, putting certain assets in a trust so that after 5 years have passed, those assets will no longer be countable at the time, no longer be subject to that snapshot review of the look back when and if someone applies for Medicaid who has set up and funded a trust. So again, the assets in the trust are fully protected against a long-term care spend down 5 years from the date that they are funded. So as an overview, the Medicaid trust cannot provide direct access to the principal assets. While the revocable trust gives you full access, it doesn't give you the protection of that a Medicaid trust will afford you. So that's a bit of a trade-off. But as we'll get to in a moment, really not a huge trade-off. Medicaid trusts can, but don't have to provide access to income. So if you have a $100,000 CD in the trust that is going to pay out 1%, you get the 1% income, or can take the 1% income. The $100,000 of principal in my example are not immediately available to you. Doing this trust, now some people say, why don't I just give the money to my kids and let them keep the money after 5 years it's exempt? And plenty of people do that. There are a lot of reasons it's not a good idea to do that. One is, if you do need the money back and the kids have gone and blown it at the casino, the money's gone. Or if you give the money to the kid and they put it in their joint account with their spouse when they get divorced, half the money's gone. Another problem with it is cost basis for capital gains purposes. If you gave them all your stock or put them on the deed to your home, they now have taken your carryover cost basis versus what's called the step up in cost basis, which is what they would receive upon your death. And we'll get to that on the next slide. So for a lot of reasons, using the trust structure is almost always a better choice than doing outright gifts if you have time to plan and want to be proactive about it. So Megan will sort of walk us through the mechanics of the Medicaid Asset Protection Trust.
Right. And so this is a sort of diagram of that trust. But again, keep in mind that when your loved ones leave our building, they're not walking out with boxes or cylinders. They're walking out with a binder with pages in it, and this is an agreement. But essentially what this allows for is one or joint, it can be a joint trust as well. So one or two trust makers would establish this irrevocable trust with the idea that they are trying to protect and preserve certain assets from the costs of long-term care. So this trust, importantly, is subject to the 5-year look back for nursing home Medicaid and that newer 2.5-year look back for community Medicaid, which is why we are considering this proactive planning. Like Rich said, your loved ones would have done this hopefully long before they end up needing that care, kind of in anticipation, looking down the road. Certain assets, not all assets, would be transferred into this trust, so retitled to the name of the trust. Those are the assets that we are trying to protect. And like Rich said, the trust can be structured in a way that says that your parents or your loved ones can continue to receive the income that's generated by those trust assets. But in order to get the protection for the long-term care purposes, they are not permitted to directly access the principal. So they can't dip in and take those trust funds out for themselves to use for themselves or apply for their own benefit. And for that reason, we are strategic about what is being placed in the trust. We try to find that nice sweet spot for what we want to protect, but what your parents or your loved ones don't anticipate needing to access at any point during their lifetime. Instead, they just want to preserve it. Your parents or your loved ones would be their own trustees. So the trust maker will act as their own trustee unless, again, there's a good reason that they shouldn't serve. And they can appoint anyone else to serve as co-trustees with them. So sometimes they will appoint an adult child to serve as a co-trustee along with them, if that makes sense. And they will also, just like we saw in the revocable living trust, they will also designate who their successors are going to be. So if they couldn't do it anymore, they already have the lineup of those trusted people who will take their place when they really can't serve anymore or after they've passed away for that sort of administration process. So here is where Rich said that the rule for principal is not exactly what it seems. So we see principal distributions are permitted to a class of beneficiaries. These are beneficiaries that the trust maker gets to designate. So oftentimes it's going to be their descendants, meaning their children or grandchildren. And they designate a class of beneficiaries who are permitted to receive principal. The trust maker, your parent, would be serving as the trustee, so they control when these distributions are made. But if they wanted to make a gift out of the trust to one of these beneficiaries, a descendant, a child, they could do that. So they control the distributions. And sometimes it's purely for gifting purposes, but sometimes it's because they realize down the road that their circumstances have changed. And now they need to access some of the principal that was placed in the trust. So they would use this kind of mechanism to distribute the funds out to one of their beneficiaries, very likely a child, and then that child would turn around and give them the funds back or apply it towards whatever it is that your parent, your loved one needs. So there is a way to access the principal without violating the terms of the trust, but it is a few-step process and it has to be done in coordination with a few other people. So we like to think of this as sort of a safety valve. We put these assets in the trust and it's based on a counseling discussion, it's based on strategy, but just know that there is a way to get them out of the trust if we needed to do that. Now, let's say circumstances have changed dramatically and this irrevocable trust now really doesn't serve its purpose. Suddenly your parent, your loved one is needing long-term care much sooner than we would have anticipated. This trust, although it's irrevocable, can also be revoked. So there are a few ways to get out of this if you really needed to, but the idea is that we put it in place for that protection, and we'll never need to use these sort of safety valves or loopholes. During the trust maker's lifetime, typically the primary residence is a common thing to go ahead and put into the trust. So if that's the case, that person is still permitted to sell their primary residence within the trust and even purchase a new residence, all in the name of the trust, without restarting the 5-year or 2.5-year clock. So you'll see on the left-hand side, if they were to sell their house, typically they would get a capital gains tax exemption for the sale of the primary residence on any gain accumulated on that home. And so they still get that exemption, even though it's now owned by the trust and not in their name individually anymore. They'll still get that benefit of getting that capital gains tax exemption. Also, they continue to get any property tax exemptions that they would have been receiving. So if they qualify for the STAR, Enhanced STAR, or veterans, or anything like that, they'll continue to get those exemptions, even though the trust is now the owner of that property. So those are sort of the lifetime benefits. The idea is that the assets will be protected in the face of long-term care. And that way your loved one can more easily qualify for Medicaid to pay for that care, rather than spending down everything that they have acquired over their life and really not leaving anything for the next generation. There are after-death provisions for this trust as well, just like we saw with the other trusts. So here we can see that after the trust maker passes away, it will have those dispositive provisions, assets divided between the children or whoever else they might designate, and they can certainly use those subtrusts that we talked about on the protection continuum. There are a few notes in here having to do with something called a power of appointment. So if the trust maker ends up deciding that they change their mind about their beneficiaries that they've named, maybe they want to add in some new beneficiaries, maybe they have some new grandchildren that they want to incorporate, or maybe they want to remove someone that they no longer have a relationship or has passed away. Using the power of appointment, they can actually make the changes to this trust, and it would not violate the terms of the trust or anything like that. So even though this trust sounds like it would be inflexible, it's still very flexible. They can change their beneficiaries and the percentages that they are receiving. And then, as Rich mentioned before, after the trust maker passes away, when those assets pass to the next level of beneficiaries, the assets that have any kind of growth or accumulation, any kind of gain that's affiliated with them, those go down to the next layer of beneficiaries, children or what have you, and they'll get a step up in cost basis, meaning that they're now valued at the date of death value, the date of the trust maker's death, and all of that gain during the trust maker's lifetime is wiped away. So when the beneficiary goes to liquidate that asset, they're not paying the capital gains tax on the gain from the trust maker's lifetime.
Yeah, and where this trust tends to be very popular, people are at or near retirement. They have a really good sense on what their recurring income is from their pensions, Social Security, 401ks, IRAs, and they know they can sock away assets here, even though we said, and it's true that you can get assets out of the trust and back to you if you need them. More often than not, people are never going to touch the assets that go in this trust. That's just the reality of the situation. And why leave them subject to a Medicaid calculation spend down if we can sock them away somewhere safe that will go to the right people in the right way after your death, get all the tax benefits of an inheritance with the same protective trust, and not go through probate and all these other things, and not get why forfeit the protection that we could get. So that's why these Medicaid trusts have become so popular, again, given the enormous 130 or 40,000 a year costs that we're seeing in our local nursing homes. So those are the two sort of major trust conversations about, what your loved ones have been doing with us over the years. Now we're going to shift gears and talk a little bit about the process of administering the estate upon an incapacity event for your family member or upon their death. So this slide just sort of runs through the life cycle process that we go through. When our clients first meet with us, we do the initial attorney interview. They're interviewing us, we're interviewing them. They say, yeah, we want to work with you. Yeah, we want to work with you too. And then we move ahead to the design process where we use our electronic whiteboard, or if we're doing Zooms, which we've been doing the last year using the Zoom whiteboard feature, we craft the plan after learning again about the family and their background and where the bodies are buried kind of story. Then the assets, the trusts are signed at what we call the delivery meeting. For probably apparent reasons, we don't like to call it an execution meeting, even though we're executing documents. We don't want the plan to mature that quickly. We then do a funding meeting. We used to do it a separate meeting. Now we've, thanks to the efficiency of Sarah, our funding coordinator, do it at the same time as the delivery. So we get the funding document signed. We also offer, and occasionally people take us up on this, to do a family meeting either by Zoom or in person back in the pre and post-COVID days, where we would actually have a meeting with the family members to explain what the plan looks like and how it's going to work. Not every client is comfortable with that, but some do like that. And then once all these things are in place, we say our clients on cruise control, they become part of the annual maintenance to go through our maintenance programs, do things like this trustee workshop, and just keep apprised and updated as necessary. And then unfortunately, something does happen to people. They either become disabled or pass away. So this is where we're going to talk a little bit about the settlement phase. So the next slide just talks about the different roles you family members on the webinar may take on in the period of incapacity. Well, you might be part of that panel to decide first and foremost if your loved one, your parent or other family member is in fact disabled or so incapacitated that they no longer really should be handling their personal and financial affairs. You may also be the primary or successor healthcare agent under a healthcare proxy to make healthcare decisions on behalf of your family member when they can no longer do so. And hopefully the third one never comes up through the planning that we do. It should never be necessary. But just to point out, there is also a third type of helper role during incapacity, which is known as a legal guardian. In New York, we have a process called the Article 81 guardianship, which requires going to court if a person doesn't have documents in place designating someone either through a trust or a power of attorney or healthcare proxy to handle both personal, healthcare, and financial affairs. In our trust structure, you may become a disability trustee or a co-trustee in the event that the panel has now said John Smith can no longer manage his own affairs. And you may also be an agent under a durable power of attorney, even when and if we have trust, which is, again, as Megan said, virtually every one of our clients that we're working with in this context is going to have some form of living trust. We always do a power of attorney as well, because inevitably people have things such as retirement accounts, 401ks, IRAs, which we cannot have owned by a trust. We do have a separate kind of trust called a standalone retirement trust that many of our clients have, but that only serves as a beneficiary upon the parent's death. So people have substantial IRAs. If they become incapacitated, the only one who can really manage those is an agent under a power of attorney. So many times the co-trustee or the successor disability trustee will also be the agent under a power of attorney. Two roles with the same general purpose. And then we'll just discuss what happens upon death. The helper role is upon death. We're going to either have, or both, a death trustee. So a person who is typically going to be a disability trustee will often be a death trustee to administer the trust assets upon the death of the parent. Of course, a disability trustee may never be needed. We hope in most cases it's not. That means a person hopefully lives a good ripe age of 100 plus and just dies peacefully in their sleep. No disability trustee needed, but we definitely have the death trustee needed. And the personal representative is in New York and in many other states called the executor under a will. We always do what's called a pour over will as well. We have the executor designated in the will. Now, if we have a fully funded trust, meaning all the assets are either owned by a trust or payable to a trust, or payable on death to named persons, we may not actually have to ever file and probate the will. And that's always a goal of ours. We always strive to have no to minimal probate. Not that probate has to be a terrible thing or is always a terrible thing. It's just a layer we would like to avoid if we don't have to do it. But even in our best laid structured plans and our best designed, and even if the plan is fully funded and fully updated, there are circumstances where things sometimes happen. A tax refund or an insurance check refund is made to Mary Smith, or they'll make it only to the estate of Mary Smith. They don't care that there's a trust. They're going to write it to the estate of Mary Smith. And so that may be a small estate proceeding that is required, that it doesn't hold up any of the other stuff we're doing for 99.8% of the assets, but for that $2,000 refund check, we may need to use the pour over will, and you as executor will have to be appointed for the sole purpose of taking that small asset and then funding it into the trust after the probate letters are issued. So another rule. So what happens if an event of disability occurs? The first thing you're going to want to do, hopefully your folks or the client who has gotten you on this webinar today has given you or gives you the information on how to reach us. You should know that now anyway, because you've got an invite or an email. Anyway, we're not hard to find. You should be able to get us. You call us, speak to me, Megan, Linda, Donna, Sarah, Lauren, anyone in our team, they'll help you out. So you say, okay, I think mom has now been scammed or is getting scammed out of $100,000. What do we do? Or hopefully a lot less than that before you find out. We're going to say, okay, it's probably time to engage the disability panel. Presumably you're on it, and probably maybe your sister and your mother's primary physician. So I'm going to share with us now. Let me dig this up here. I'm going to share this now. Hopefully it works okay. Yeah. So can everyone see this portion of the trust? So this is a sample language from a revocable trust that brings us to the determination of incapacity. So we just wanted you to sort of see what it looks like in the trust agreement itself. So what it says here is this is your disability panel. So it says, I, the parent client, says, I will be considered incapacitated if my disability panel, by unanimous written opinion, signed by each member of the panel, determines that my then existing circumstances fall within the definition of incapacity as provided by Section 501. And so if it's quite clear to everyone involved that mom has lost her marbles, right, then the panel, which in this case is John and Sandra, the two kids with the doctor, will then sign the disability certificates. So what did that look like, the disability certificates? Okay, well, here's a sample of what it would be signed by the physician. We know doctors are very busy, so we want to make it real easy on them. And frankly, we don't really need it notarized in New York as a general proposition. This one has a notary, but make it even easier. No one tends to want to certify, so forget that this is on here. Just assume this is really all the disability certificate of incapacity consists of. Signed by the doctor, dated. That's one prong of it taken care of. And then this would be your disability certificate. It says, as a member of Robert Doe's disability panel under his trust, along with the evaluation by Dr. Jones, I, John Sample, have determined that Roger Doe is incapacitated and is unable to effectively manage his financial and legal affairs. So this certificate tracks what the trust language says. You sign it, your sister signs it, the doctor signs it. That is all that is really necessary to then take away the authority that your parent has given you permission to take away based on the provisions of their agreement. And then we would have you sign an affidavit of trust that says, in essence, by reason of the incapacity of Roger Doe, the trustees currently serving are, and then whoever the trust instrument names would probably be, in this case, Mary Doe and Ralph Mouth, right? And then the new trustees would sign this trustee affidavit. It would be notarized, and that is all you need to then provide, and we would do it with you or for you, provide to Merrill Lynch or Schwab or Fidelity, wherever the parent's money is, Citizens Bank. That then says to that financial institution, I am now in charge, or we are now in charge. If Roger goes back and says, I want to give the guy in Uzbekistan another $100,000, you don't give him the money. He doesn't have that legal authority anymore to do that. So that's sort of the disability mechanism process that you are going to be, maybe, hopefully not, but maybe having to get involved in at some point during your lifetime and your parents' lifetime. So that is that piece. So let me go back to our screen one here. Is the right one up there now?
Yes.
Good. Okay. So take us through some of the next pieces.
Sure. So if we're looking at the potential need to do some kind of asset transfers or whatever the thing is that you have to do now that you have taken on that role, you're the appointed person, successor trustee, or what have you. You're really going to want to start by looking for asset information. And when we do our planning, we do have a dedicated funding coordinator that helps us from the outset to make sure that everything is funded with the estate plan in one way or another. So typically we already have a list compiled. So we would be working with whoever the successor is to make sure that we have all of the most accurate information for the assets. And then if any kind of transfer is needed, depending on what situation your loved one is in, maybe they're now preparing for some kind of Medicaid application, or really we're just trying to get a handle on the assets, we have different documents that might be helpful in making sure that these assets are being handled correctly. So sometimes it's a matter of a letter of instruction, right? We prepare something together, we all agree on how the asset should be handled, and that can be submitted to the financial institution along with proof, just like Rich was demonstrating, the affidavit of trust, proof that you now have the authority. You can be the person that they contact, they disclose information to, and you're the one who authorizes the transaction to take place, whatever it is that we're asking that institution to do. So in there, obviously, you would be identified as that person with authority, that successor trustee. Also attached would typically be those certificates of disability to show that everything has been executed appropriately. And then sometimes there would be something additional called a certification of trust, which is very similar to that affidavit of trust. Just depends on the kind of trust that you have. But it basically certifies the trust is still in effect and all of that same information that you would find in the affidavit.
Right. And some financial institutions have their own certification of trust that they'll want you to sign specific to that institution, which is not a problem.
So now that you're serving and you've taken on the role as the successor trustee, it's your job to manage the trust assets. And sometimes, depending on the estate plan that's put in place, that can be sort of a very laid back role. I mean, you have to oversee everything and make sure that all the assets are still doing what they're supposed to be doing. Maybe they're invested. So you got to talk to that financial advisor every once in a while, check in on the growth, or make sure that the different tax filings are happening. But otherwise, maybe there's not much else to do. So that might be the more silent role or the more silent kind of trustee.
And I'll interject too. A lot of this also pertains to when we have co-trustees, say two children are serving together. One thing that's important is they can delegate duties. A lot of times the parents, and for good reason, want, if they have two kids, they want them both to be trustees. They don't want to pick one over the other. But at the time that the kids have to step in for this role, maybe one is at a point of life or where they're living, or, they just don't have a lot of the time. So we do have the ability to delegate between trustees. So the fact that someone is a co-trustee doesn't necessarily mean they have to have equal involvement and input. So one can say, hey, Johnny, I'm really crazy. I got 4 kids under the age of 6. Maybe you should take the role here. I'll sign a delegation agreement and let you take over. And that's really an important consideration.
Right. So depending on the kind of document that's in place and the role that you and maybe your co-trustee really decide amongst yourselves that you want to take, you can take the back seat, be the silent co-trustee, or you guys can both choose to be the active trustees, both of you getting involved, hands-on, and really dealing with the trust instrument. You have to follow the instructions, and the instructions are in the trust, essentially. So the trust outlines what should happen to the trust property, and it's your job as the trustee to make sure you are adhering to those guidelines laid out in the trust. So typically there will be some kind of direction for how the trust assets should be managed on incapacity of a trust maker, and you have to make sure that you are within those guidelines. Many times they're not asking you to jump over hurdles or anything crazy. Just make sure that those assets are being monitored, and that you're checking in and doing the appropriate tax filings. So you really have to make sure you are following the guidelines set within the trust itself. And ultimately, as the trustee, you have a fiduciary responsibility. Like I said, you have to follow the trust guidelines, and you have to be acting in the best interest of your loved ones, provided that they are still alive. And in this case, they're just disabled or incapacitated, so they can't do it themselves. So you are this trusted person. And if you don't do what you are supposed to be doing, maybe you make some kind of misstep and you call us and say, did I do something wrong, right? Accidents happen, but we have to make sure that they're not happening, or they're not happening frequently, and that you don't do anything maliciously. So if you are unsure about your role, that is when you contact the attorney or you reference the documents that we have given you, because you do have that fiduciary responsibility. So it's really important that you're doing the correct job.
All right, going back to one of the earlier slides near the beginning where I said, during the revocable trust, it doesn't have the feel of a real trust. We're at the point that this is a real trust. You have a fiduciary duty, which is the highest legal standard of care to to all the parties of the trust, the beneficiaries, the grantors, whatever, right? You got to follow the duty. And it is no excuse later on that said, well, I've never done it before. I didn't really read it. And so I just gave all the money to my mom, even though the trust says right in there, for, let's assume it's a Medicaid trust, under no circumstances can you give the principal back to the trust maker. You do have an obligation to know what you're doing. Now, the good news is if you're working with us, we're going to coach you through all that, so you're not going to screw up. But for those people, and there are people who do these trusts and don't do maintenance or whatever, those are where these trusts fall apart and people, don't do the right thing. And if a fiduciary does something contrary to the trust instrument, they may be legally liable to it and be out of pocket serious money if they screw up or don't invest it properly. So it's not a job to be taken lightly.
Right. Continuing to talk about management of the trust and trust property, there are a few areas that you have to be very careful with. Specifically, one is with gifting. Typically, people immediately are thinking about gift tax and tax implications, and that's absolutely something that we should be concerned about. But really, you shouldn't just be making gifts unless I think you are instructed to, would be a good one, by maybe us as the attorneys, and probably in conjunction with an accountant if they needed to get involved for tax purposes. But gifting is something that you need to be very wary of, because a lot of the Medicaid planning that we're doing and long-term care planning that we do with your loved ones, really that takes gifting into account. And as we talked about earlier, when we were talking about Medicaid, gifting can create a penalty period. So you shouldn't be just simply gifting out of the trust or out of your parents' assets, not only because you could be violating the terms of the trust itself or the legal document, but you could be causing some kind of great havoc on the plan itself overall, because now you've gifted and it's going to create some kind of Medicaid penalty, or you'd be subject to the look back period. The other thing is retirement plans. Obviously, we have different tax concerns associated with retirement accounts. And so you don't want to just be withdrawing funds whenever, because it's going to be a taxable distribution. But you also don't want to forget to take the RMDs, or, make sure that it's coming out and going to your loved one, your parent, if they are supposed to be taking their required minimum distributions. So as soon as we start seeing that there are retirement accounts in place here, pay special attention to those. If something seems like a gift, or it's an uncompensated transfer, maybe it's something you wouldn't think of as a gift, but it's simply moving money out of your loved one's name, that's a gift. So now you say, okay, maybe I need to talk to someone about this. Don't just do it without being advised first. So now we come to during the disability portion still. So your loved one has not passed away. We have some healthcare decision making. And there are different mechanisms that can be used for this, but we're going to take a look specifically at the healthcare proxy. That is the document that your loved one would execute, typically along with something called a HIPAA release form and a living will. But in the healthcare proxy that you can see here on the screen, this is where your loved one would designate another person, maybe you or maybe someone else in the family, to be able to make healthcare decisions on their behalf in the event that they can't make that decision anymore themselves. So if they become incapacitated, just be aware that in that binder of all of their important paperwork, you're going to want to look for those healthcare documents. You're going to want to see who has been designated as the agent to be able to make those healthcare decisions for them. So you see there in the first paragraph, you're going to see the person is the principal, that's your loved one, and then you see the agent, and that's Robert in this instance, and that's who's been designated as the healthcare agent. So that allows Robert to make healthcare decisions on Mary's behalf now that she's been determined that she really shouldn't be making those decisions. She's now incapacitated. Sometimes our clients will list specific wishes, instructions, or limitations on this form. So if they do, you have to adhere to those. And they may list anything. It could be something that seems bizarre to you, but it was important enough for them to write down. So you really do have to adhere to any of those wishes that they may have written down, or that they may have conveyed to you. Maybe it's even orally at some point. But if you understand what their wishes were, it's really important that you do adhere to those wishes. Included in here is going to be the person's backup agents as well, so the successor agents. So maybe the hospital or medical provider could not get a hold of the first person on the list, then they're going to move down to Sally. So if they couldn't reach Robert, or he wasn't comfortable making a decision, they're going to reach out to Sally, and they're going to ask Sally to make that decision. Now, Sally is permitted to consult with other family members, if that makes sense. So maybe Sally is an adult child and she wants to consult with Francis on the decision, she could do that. But Sally would be the ultimate person to make the decision, since she's next in line. So it'll be up to her. There's also typically organ donation provision included, so anatomical gifts, where your loved one may have indicated whether or not they want to be an organ donor, or to what extent they would be okay donating their organs. So there are a few options here. And then obviously with all of our documents, people can customize this a bit further. And so sometimes people will. But again, you have to adhere to this. If they've indicated that they would like to donate their organs, you have to keep that in mind, and you have to let the medical providers know if it comes to that point where we're discussing organ donation with their doctor.
Yeah, and under New York law, you can only have one designated healthcare agent at a time. You get multiple agents under a power of attorney for financial matters, only one healthcare agent. But you can put some of our clients put in the instructions here, even though Robert is the agent, I do instruct him to consult with all of my children before making any final decision. But he would have the final say in doing whatever the healthcare decision is. So let's stop with that one. And I'll bring up, that's not it. Oh, here it is. So we have here, let me bring this up on the screen here, and I'll share it in a second. Here we go. Okay. Is the living will up there? Okay. So the living will, some attorneys combine the healthcare proxy and living will. We prefer a separate document. This is the document which will specify whether to the extent that the client wishes to terminate life-prolonging procedures in the event they are deemed to be in an irreversible and terminal condition. So this is just the form of what it looks like. The triggering mechanism, again, you as a layperson can't just say, oh, mom is not going to live, let's pull the plug. That's not in your skill set. So even if you're a physician, as a family member, you can't make the decision. So it is a medical determination. So here you can have my attending physician and at least one other consulting physician. Some clients will just have my attending physician alone can make that determination. Once that a medical decision has been triggered, the instructions here would be to say to terminate life-prolonging procedures, feeding tubes, respirators, all that kind of stuff. I wish to die naturally, and so on and so forth. Not every client, I'd say probably 9 out of 10 of our clients have living wills. Some of them just aren't comfortable having the language. They just do a healthcare proxy, leaving it really within the discretion of the agent to pull the plug, not with any guidance, unless it's oral guidance, as Megan indicated before. So we just want to show you what those documents look like. So going back to the screen. So we talked about the healthcare instructions, the termination of care issues. We are now going to move ahead, or have to get this off my screen so I can do that. Okay, there we go. So then what happens after death? Well, every one of our clients has the red book. You may have seen it, you may not. More likely than not, I'm guessing you have. It's a big red binder, and that book is something. In fact, I'll grab one from my shelf. Excuse me a second. This is my father's binder, so I keep it here. He's 90-year-old and kicking and still going strong. But if something happens to him, I have the red book. I know where to turn, obviously, having done this a few times. And I'll make sure that his instructions are carried out. You want to make sure that if you haven't had a conversation with your parent or loved one about it, that you know what their organ donation wishes are. So of course, some people have it on the driver's license as well. And if it says, yes, I'd like to be an organ donor, of course, you can inquire of the physician if that's something they can do. You want to look at, there's memorial instructions in the revocable trust books, especially. If there is any funeral or cremation or burial instructions, you want to know that. And of course, you want to call the law firm. Our business cards are in the front of every one of these red binders, so you can gain access to us and reach out to us by phone or email. It's not a crisis. I mean, it's a terrible thing when a family member dies. I'm talking legally, of course. Nothing has to be done immediately. I just want to make sure that you understand that. So go through the grieving process in the family. You can contact us days, weeks later, and we'll pick up from there. You can meet with us. Of course, some people are not local. We can do Zoom meetings. Anything good come out of the pandemic, we know how to use Zoom very well now, right? So if you're in Colorado or Texas or anywhere, we can have a meeting just like we're sitting across the table. We're going to talk about who's in charge and who makes decisions and how, and so on and so forth. And just like we have the disability affidavit of trust, there's a similar process upon death. There's a trustee affidavit that would say, Mary Doe has passed away. A copy of the death certificate is attached. Under Article Section 3.01B, I am the named successor trustee. And a lot of the same process with disability. Here, there are going to be more active transfers typically, because we're going to go from mom's trust to the sub-trust for the children. And you as the trustee are going to be in charge of that along with the law firm. Of course, if there are debts, whether it's credit cards or taxes or other things, all that should be paid and has to be paid to legal creditors before distributions can be made to the beneficiaries, as well as taxes. Now, in the book, there's a personal property list that may or may not be completed. We actually have a form that is a memorandum format, a template that your loved one may have completed. and said the candlesticks, grandma's candlesticks goes to Sally. The family genealogy book goes to Johnny, or the toy soldier collection, whatever. If there's nothing on the list, or to the extent that it's not on the list, typically, not always, but typically the personal effects will just be distributed among the children, substantially equal shares. Again, we're going to work together with the financial institutions, the banks. If there's real estate that has to be conveyed, it'll be done by deed that we would handle. And of course, we'll talk about what the beneficiary, how their inheritance is structured. Almost always going to be one of those trusts that we talked about earlier, and how you administer that. We'll get a tax ID number for your new trust, which again is not a separate legal instrument. It's in my father's trust, it could be section 8.02 of the Arthur Shapiro Trust. That would be the trust for me. Section 803 would be for my sister, probably vice versa because she's older. and we would walk you through that process. So there are steps to take. It seems a little daunting at first, but with our experience and your patience, we get through it pretty quickly, and you're good to go. And most importantly, it's done with very minimal, if no court supervision, a much quicker time frame. And again, everything that coming to you should be in a protected form, so that if you have people chasing after you for money, hopefully not, but if you did, either now or in the future, they can't take away what your parents left for you. So that takes us to the end. Hopefully you found this a good, useful, roughly hour and a half of your time. Again, this is being recorded, so if you want to catch up on something or get further clarification, you can go to the recording. We are here for you with questions going forward. If you have a quick question for us, by all means, reach out to either of us or anyone on our team. We should be doing this again in the fall sometime. I think we have on the calendar for September, October, maybe in person, maybe Zoom. We don't know yet. But hopefully, again, you found good use of this. We enjoy working with our clients, and we want to be here as a resource. So with that being said, we'll bid adieu. And Megan, anything else to add tonight?
I'll just thank you everyone for sitting through this with us. And like Rich said, we're here for any questions that you might have.
Thanks again. And this is who we are, and we're here for you and your family. So we thank you again very much. See, there might be something in the chat. We got a few thank yous. Thank you very much. Enjoy your dinner and all that stuff. I'm going home. We should have a new car that my wife picked up today. I'll be looking forward to seeing that. And we again thank you for your time. Have a good evening and good luck.